And I have the pleasure of introducing our speakers for today. We do have three speakers. Dr. Margaret McGladrey received her doctorate in sociology from the University of Kentucky and completed a postdoctoral fellowship in civic studies at Tufts. Dr. McGladrey is a research assistant professor with the Center for Innovation in Population Health and serves as the criminal legal system faculty co-lead for the Healing Communities Study Kentucky. She has expertise in community engagement and participatory research, as well as quality improvement and program evaluation in complex systems of care. We also have Susannah Stitzer today, who's a project director for the Criminal Legal System Healing Communities Study at the University of Kentucky. Stitzer earned her JD at the University of Kentucky College of Law and her MPA at the Martin School of Public Policy Administration. Prior to joining HCS, Ms. Stitzer managed an interdisciplinary neuroscience research program at the University of Kentucky. And finally with us today, we also have Gabby Deaton. MSW currently serves as a prevention specialist coordinator for the University of Kentucky's Healing Community Study. The historic NIH grant is focused on reducing opioid overdose deaths in the Commonwealth and throughout the country. In her role, Gabby leads a team of staff in providing overdose education and naloxone distribution direct delivery throughout our 8 counties. She received her Master of Social Work degree from the University of Kentucky in May 2023. So welcome to all of our speakers today, and I am now going to hand presentation mode over to Dr. McGladrey for the beginning of the presentation.
I just want to take a minute beyond the introduction that Chris already provided for us here to talk a little bit about how we're going to be structuring our conversation today. So I'm going to be talking as the Criminal Legal System faculty co-lead, and I was also the former project director of the Criminal Legal System implementation team in Wave 1 before Susannah joined the team and I took on a faculty role. So I'm going to be talking a little bit more about the conceptual aspects of how the criminal legal system is organized, the way that it works, and how it intersects with opportunities to divert people to behavioral health care interventions like OUD prevention and treatment services. And then Susannah is going to follow me along and talk about the application of our HCS interventions at these different kinds of points in the criminal legal system process here. So that's the way that it's going to go. It'll be her and I talking a little bit through each of these aspects of the criminal legal system and what we've been doing at each of these intercept points between this intersection of the criminal legal system involvement and behavioral health, as you see on our title slide here. And then at the end, we're going to have the opportunity to hear from Gabby in a more informal way about her experiences providing direct delivery OEND in this session. And as Chris had talked about earlier, we are going to be focusing primarily on OEND, overdose education, naloxone distribution, going forward with this session. But next week, we're going to be doing a deep dive into MOUD, linkage and retention services in HCS. Okay, so just to review very briefly our goals for today, in terms of practice gaps and educational needs, here in Kentucky, the Kentucky Department of Corrections is the largest provider of substance use disorder treatment services. But behavioral health providers often lack training on how the criminal legal system and involvement in the system affects clients' ability to participate in services. So that's a really important thing to let sink in. In Kentucky, the DOC is our largest provider of SUD treatment services, right? And often as behavioral health providers, we don't have the understanding or the training on what that parallel system and process is doing. So a second point here is that it's critical to understand how involvement in the criminal legal system can be reduced through diversion to treatment, as well as the complications with providing SUD services to people in government custody. And there are many of them that we'll be talking about here. So in terms of our learning objectives, we're going to be explaining how SAMHSA's sequential intercept map approach and the 6 intercept points where people involved with the CLS can be engaged in overdose prevention and SUD treatment, so you all understand that model. And then we'll describe best practices for implementing opioid overdose education reduction strategies in the criminal legal system from our experience with the Kentucky Healing Community Study. And we'll also be recognizing the respective roles of alternative sentencing workers, social service clinicians, and other practitioners who work in the criminal legal system in facilitating treatment and providing overdose prevention resources for people involved in the system. And what we hope are the expected outcomes of these series of trainings is that you all will understand how criminal legal system processes and rules affect SUD prevention and treatment in Kentucky, and enhance our understanding of opportunities for collaboration and communication, and the environment in which collaboration and communication takes place for serving folks involved with the criminal legal system and behavioral health treatment, and how we can adapt to these complications in practice. So I'm going to take it to the polls here. Chris, if you'd open up our first poll. We have a couple of questions here for you all. I'd like to hear a little bit about everybody's relative experiences in the criminal legal system, either as professionals or as, Chris, it's looking like it's the first poll there. So in the polls, you'll be seeing these questions, whether you have personal or professional lived experience with the criminal legal system, and then a little a brainstorm question here to make sure we're all on the same page about what we're talking about with the prevalence of criminal legal system involvement in the United States. I love watching the responses come in. It's always so entertaining. We have a great number of folks in this room, Zoom room, who have some professional or personal experience from what's coming in on the polls that I can see. Keep those responses coming. Got another 10 folks. Yep, we're almost there to full participation. Get those final answers in here. All right, and I'm going to adjust my microphone here as Chris closes out the poll, and we can see what our answers are. All right, in this room, we have a lot of collective experience here with 79% of folks in the Zoom room here who have some personal or professional experience with the criminal legal system. And then we have a range of different responses to our second question. The United States is home to 5% of the world's population, yet houses nearly what percent of the overall people who are incarcerated? So let me turn off my microphone here and see if I can get this to adjust here.
All right, so Chris, are you sharing the results here?
Yes, so everybody can see, should be able to see the results.
Okay,
right now.
wonderful, wonderful. So the correct answer to our second poll here is 25%, almost 25% of the world's population. Isn't it interesting, though, that our top response was 30%, that we assumed that it was actually more than that because of the predominance of kind of the criminal legal system overrepresentation of the population in the United States here. So let me go ahead and go back to my slides here. Hopefully they'll cooperate with me. Give me 1 second. I'm get it out of presenter mode. My computer is like throwing everything possible at me today. Here we go. So it should be slides now. Okay, great. So before we get into some more of the content of our conversation here, wanted to provide a little bit of a note on language. So previous Kentucky Open sessions have discussed the importance of using person-first language rather than terms like addicts or junkies that perpetuate stigma against people experiencing substance use disorder. So think about this when it comes to the criminal legal system. What's the worst thing that you've ever done? Imagine being known by that one mistake, regardless of what you've done to take responsibility or to make amends. You have to write it on top of every application for employment or housing that you ever fill out for the rest of your life. That's what it's like to be in a position where one of these labels might be used to apply to you. So we use person-first language instead of the terms on the left side of the screen here so that we don't contribute to the ways that these labels create stigma and perpetuate stigma against people who have been involved with the criminal legal system. Another thing that you'll hear me and Susannah talking about is we're using the term criminal legal system, or CLS, as opposed to maybe a term that might be more familiar, the criminal justice system. And as you see on the two links down here at the bottom of the slides where some of this language and ideas on language came from, the really wonderful Vera Institute, great source of information and guidance around criminal legal system issues. Two different reasons why we use criminal legal system, or CLS, rather than criminal justice, or CJ, to describe the system. One is, as something you'll be hearing from Susannah in a minute here, the criminal legal system, especially when we think about our county jails, it involves people who have not yet been sentenced, right? So there are folks who have not been sentenced, but yet are involved with the criminal legal system. So to say that they are criminals and are in due receiving of justice, right? We are talking about typically 40 or 45% of our county jail populations are folks who are pre-sentenced. So they've not been convicted of any crimes here. And so another point here is that for a lot of advocates for abolition and for reform of the criminal legal system, our system doesn't produce justice. So calling it the criminal justice system isn't an accurate representation of what the system is designed to do. So instead, we use the criminal legal system as our terminology. So I'll turn it over to Susannah to tell us a little bit more about the state of affairs here in Kentucky with the criminal legal system.
Thank you, Margaret. So first question is, how does incarceration look like in our state? The link here to the Sentencing Project will take you to a whole wealth of data where you can look up all kinds of statistics. But the primary one we pulled from this is that in 2021, Kentucky's imprisonment rate was 411 for every 100,000 Kentuckians, ranking us 9th in the country. But this doesn't include individuals who have been sentenced and are now housed in our state and federal prisons. Sorry, that only includes sentenced individuals in those prisons. It doesn't include jail admissions or probation and parole. When we expand our full scope to get the full perspective of Kentucky's incarceration rate, the numbers are staggering. Next slide, Margaret, sorry. Thank you. So what you'll see here is when we incorporate the juvenile justice facilities, immigration detention, as well as jails, we find that Kentucky has a total incarceration of 930 per 100,000 people, ranking Kentucky 5th in the nation. As it is, the US vastly exceeds other democratized and NATO nations with its incarceration rates. So when analyzed in that context, Kentucky is not only higher than most other states for their incarceration rate, they're outpacing most democracies throughout the planet. Each year in Kentucky, 89,000 different people will pass through our jails. And what we know is our system isn't equipped to manage those kind of numbers. The majority of our jails are operating over capacity. 43% of Kentucky's jails are considered dangerously overcrowded, with some operating at more than 200% capacity. And as Margaret referenced, we know that approximately 2/3 to down to about 1/2 of the jail population hasn't been sentenced and are simply there awaiting trial or sentencing. What we understand next is the sort of the population that we're talking about. 45% of Kentucky's jails population have a mental health disorder, and an estimated 80% have a substance use disorder. Many have both. In fact, what we know about individuals with co-occurring substance use disorder and serious mental illness is that they're overrepresented in every part of the criminal legal system. They're more likely to be arrested, booked, convicted, and incarcerated than those with only a serious mental illness, those only with a substance use disorder, and those with neither. They have higher rates of recidivism and shorter times between rearrests with comparison groups. We also know that only 12.7% of people with co-occurring conditions received any treatment for either condition. Particularly relevant to HDS's population are people who are incarcerated with opioid use disorders, and there are challenges particular to them. Many people untreated during incarceration will experience a reduced tolerance to opioids, which means once they leave, they often return to the level of prior use and are much more vulnerable to overdose. In Kentucky, we know the risk of death for released inmates, individuals who've been incarcerated, is 12.7 times higher within 2 weeks of release than for state population residents. Several factors contribute to this, but a dearth of resources and care is at the top of the list.
Thanks, Susannah, for giving us a sense of the landscape. As I mentioned before, we're going to be doing kind of a deep dive on OEND partnerships and giving you all a little bit more information about each of the steps of the criminal legal system involvement in that SAMHSA sequential intercept map in this session. And then next session, we're going to be talking more about the MOUD linkage and retention activities that we've been pursuing. So stay tuned for next week and please come back and join us for that. So as you see in this complex visualization here from the National Institute of Justice, there are a lot of ways that people move through the criminal, here they have criminal justice system, the criminal legal system, and you can kind of use the color coding to take you from the original blue experience of a crime to the entry into the system, prosecution and pretrial services, into purple, that adjudication space where decisions are being made in court, then to sentencing and sanctions, and then corrections. So you might take here as a visual as you're, as I'm describing some of these kind of pieces, maybe follow your way through one of the pathways that could happen in this chart here, all the different kinds of decision points based on charge type, all the different kinds of ways that people can move through the system given these different kinds of decision points here. But first, I just want to take us to this light blue area, entry into the system. So I'm a sociologist, right, as Chris said at the beginning, and it's really important to point out that crime is socially constructed, right? What do I mean by that? That means that there's a shifting consensus on what behaviors should be criminalized and what behaviors should be punished in the United States and in specific state jurisdictions. So for example, in Kentucky, we still have these two following laws on the books. These are real laws in Kentucky. First, before automobiles changed the way we traveled, most of our ancestors got around on horseback. As we know, in Kentucky, lots of horse trails. Along the way, some would-be travelers would spot someone else's horse and try to lure it away by putting an empty ice cream cone in their back pocket, stealing the horse with the enticing ice cream cone. True story. So because of that, a law was written, one that still applies today, that forbids you to carry an ice cream cone in your pocket so that you don't steal those horses. Another law that's still on the book in Kentucky, at least once a year, you must shower. Did you know you are legally mandated to do this in Kentucky? So again, this gives us a sense of the extent to which different kinds of behaviors that we would just laugh off as how could that possibly be criminalized? How could that possibly be subject to any kind of legal intervention? Those kinds of laws are still on the books in a lot of ways, and it represents the ways in which we as a culture, we as a society change what we think is deemed worthy of being criminalized here in terms of behavior. So another really good example of this, especially as it regards substance use disorder, decriminalization of marijuana, right, cannabis. When we think about the regional variation that's happening, looking across all the different states in the United States, where recreational marijuana is allowed, where medical marijuana is allowed, under what kinds of conditions, when from a federal law perspective, cannabis is still a Schedule I drug, right? So who gets involved in the criminal legal system really depends in some cases on where they live. This is really similar to some of the conversations we have about the social determinants of health more broadly, right? Where your biggest predictor of health outcomes can be the zip code that you reside in. A similar kind of logic can be applied to the criminal legal system when we think about the differences and the variations and how different laws are applied and the ways that crime is constructed and understood in different kinds of jurisdictions. What's criminalized, what's actually prosecuted, right? All of these are subjective and socially constructed. So just to give you a brief overview, and we'll be hearing more about this as we go, in the Healing Community Study, we are typically working, a lot of our interventions are in this space around prosecution and pretrial services, especially working with folks with misdemeanors here, but we also are working with folks in the correction space, both probation and parole, as well as the jail outlet that you see in this yellow part of the chart.
So that you can see exactly how this type of processing impacted HCS's work, the graphic at the bottom is SAMHSA's sequential intercept map, highlighting the points of intervention at which we can identify and provide services to people with OUD, as well as other mental health and substance use needs. Throughout the HEAL study, the criminal legal system team has tried to impact as many of those intervention points, and along with guidance and support from the county coalitions, we've been able to implement strategies across all of them at some point in both study waves. For overdose education and naloxone distribution strategies, which we'll get into more in depth in just a minute, they've been implemented with law enforcement agencies, pretrial services, county jails and home incarceration programs, specialty courts, including drug, veterans, and mental health courts, and probation and parole. Our medications for opioid use disorder linkage and retention strategies, it's just a bit of a mouthful, were implemented in jails, specialty courts, and probation and parole. And at the moment, we are in process of developing a peer support with the county police department. And so we'll have provided that across all of those agencies except for pretrial services at the end of the study.
Thanks so much, Susannah. And as you probably noted here, we've got kind of the color code of these intercept points, these points at which criminal legal system involvement could be diverted or deferred to behavioral health kind of intervention, color coded with the sequential intercept map here. Thanks, Susannah. Okay, so deeper dive, and a lot of you on this call could probably give this description better than I can because you do this day in and day out, our overdose education and naloxone distribution strategy. To just give you a sense of what this is conceptually, our HCS agency partners, and typically that's what we're doing with the criminal legal system teams, is we're partnering with agencies along this sequential intercept map, as Susannah said, each of these different levels of the system here. We are partnering with these agencies to provide OEND to participants in and clients of the program, as well as their family members. because we know that increased distribution of Narcan means more saved lives from the evidence. So per Kentucky revised statute, overdose education must cover 7 key elements of recognizing and responding to an overdose. First, what are the risk factors for overdose from opioids? What are some strategies to prevent opioid overdose? Third, signs of an opioid overdose. Fourth, steps in responding to an overdose. Fifth, information on naloxone. 6, procedures for administering naloxone. And 7, proper storage and expiration of the naloxone product. And education, this overdose education, can be delivered via a variety of different kinds of modes and methods to meet participant and agency needs. So our prevention team has created a lot of different kinds of resources for this. We have a video that we've used in strategic ways you'll be hearing from Susannah about, as well as in-person training by competent individuals. For example, reviewing the HCS brochure, verbally reviewing that with someone that you're going to give a Narcan unit to. So after receiving education that follows the KRS guidelines for those 7 points that we need to cover, individuals who are clients or family members involved with the criminal legal system receive from their agency or another system you'll hear from later, a unit of naloxone free of charge. And we really are prioritizing high-risk populations, of course, including folks involved with the criminal legal system for all the reasons that Susannah described around the increased overdose risk rate. And this is also a pro-social tool for bystanders. And Gabby's going to be telling us a little bit about ways that we can kind of overcome the stigma around who carries Narcan and why, and that carrying Narcan becomes a pro-social tool that can be used to help demonstrate folks' commitment to recovery and reentry into the community. Another thing I'll note here too, that this strategy, OEND, is closely aligned with allowable uses of opioid abatement funds. So KRS 15-291-5A3 and KRS 15-291-5B24 allow reimbursement of prior expenses or funding projects for any portion of the cost of administering an opioid antagonist as defined in KRS 217-186. And then according to KRS 217-186, opioid agonist means naloxone or any other U.S. FDA-approved drug designated to reverse effects of an opioid overdose, like Cloxato, for example. So let's work our way through each of the intercept points at which the criminal legal system has been partnering with agencies to provide these different kinds of interventions. So first, we partnered with, we have the kind of examples of these different kinds of first responders at intercepts 0 through 1, coded in that orange from the sequential intercept map. Now, when you think about the difference between a police department and a sheriff's office, typically what we're talking about are police departments are run by local cities or town municipalities, compared with sheriff's offices, which are run by county jurisdictions. We also have other first responders in the mix, like EMS, who are often co-responding with the criminal legal system, crisis responders, police, and sheriff's departments. Although state and national professional associations exist, like we have the Kentucky Sheriff's Association, it's important to know that these agencies are locally run and funded. There's no state level body that is authorizing, governing, and running our police and sheriff's office departments here.
So as Margaret said, I'll be getting into some of the weeds about how HCS and specifically the criminal legal systems team applied some of these strategies. With our local law enforcement agencies that were selected, especially throughout Wave 2, the call was less for them to participate in distribution of naloxone as part of their practice, but instead coalitions wanted to ensure that our police and sheriff's departments are carrying and using naloxone as a resource. What we wanted to do was to adapt to their needs, especially because it was a different approach. We understand that from a police perspective, there are different concerns. They had bigger questions about liability, more concerns about stigma and their role in the community. And one that's often at the top of their list is their role as an emergency responder and whether or not this should be left to the emergency medical services. To accommodate the law enforcement agencies, we changed our strategy. Several were selected in each county. And so we worked to identify a champion law enforcement agency to host information session. We identified those champions. Often we had coalition members or we had police departments that we knew were advocates for naloxone. And so we would ask them to host and invite their county counterparts to the session. We've also been incredibly fortunate on HCS to have a retired police officer on our staff. He was able to attend those sessions and provide his perspective, not just as an advocate for naloxone distribution, but as a police officer that had onboarded naloxone as a resource for his officers and could talk about how that experience had gone. We also incorporated our prevention specialist, Gabby, who is here with us today, did an amazing presentation to the Campbell County Sheriffs. She was able to talk about her perspective and how she's been engaged with the community. And having that one-on-one engagement, we found really drove things home. The biggest adaptation, though, we made, much like distribution wasn't going to be a pragmatic consideration for police officers, so was a question of training. HCS has a series of processes and there's a documentation component. And what we didn't want to do was ask police departments with limited time and capacity to learn one process, and then as HCS exits the field, try and find the time again to teach them another. So what we were able to do is direct them instead and provide education on ordering naloxone through the Kentucky Pharmacists Association. KPHA has a partnership with the Office of Drug Control Policy and Van Ingram to provide naloxone at no cost to law enforcement agencies throughout the state. And so that really gave us this sustainable option so we could provide education, encourage naloxone use as a resource by officers, and do it in a way that would provide minimum burden and involvement from us.
Thanks so much, Susannah. And as Susannah said, the emphasis here is rather than kind of with our original strategy here, we're really trying to encourage our agencies to not only have naloxone, but also to educate their participants and distribute it. The focus here with the law enforcement agencies, given that they're at this 0 to 1 intercept point in the sequential intercept map, is making sure they have naloxone on their person, on their utility belt, so that they can use it in the event of emergency, especially if they're the first at the scene before the EMS are able to be there. Okay, so we're going to be moving to the next point in the criminal legal system intercept model here. And you're seeing on the screen a very complicated organizational chart for the administrative office of the court. And so here's where we're starting to get in the point of the criminal legal system, where we're moving away from local only kind of management into state oversight. So you see here with the stars within this complicated org chart. And at the very top, Chief Justice of Kentucky, John Minton here, and we have all these other kinds of resources around the administrative office of the courts here. But under programs and personnel, we have lots of different kinds of services, Department of Juvenile and Family Services that provides the court designated worker program. But we also have the Department of Specialty Courts and the Department of Pretrial Services. So that's where these two agencies live in the complex state hierarchy of the criminal legal system. And this kind of complex hierarchical system is why we really needed to prioritize state level coordination and buy-in before working with some of our local agencies that have this kind of oversight. So again, one of these agencies is Pretrial Services at Intercept 2 here, and I'll tell you a little bit about what they do, what their mandate looks like. And again, remember that they are under the administrative office of the courts here. With Pretrial Services, this is really a service that is based on the premise that defendants are entitled to the least restrictive terms possible, depending on whether they're likely to appear in court and whether they present a risk to public safety before sentencing. So in Kentucky, pretrial service officers are mandated to conduct an interview and investigation of all persons arrested and booked into jail on bailable offenses within 24 hours of arrest. And that was decreased to 12 hours with a April 14th Supreme Court order. Since 2017, pretrial has had statewide delegated release authority for certain types of offenses. What that means is that the pretrial risk assessment immediately upon arrest, and based on with the charges and the score with this assessment, pretrial is able to release without contacting a judge in order to keep the docket moving, right? How can we get those folks moved along without having to see a judge? Then on April 14th, 2020, the Supreme Court ordered an expansion of delegated release authority to include all nonviolent, non-sexual misdemeanors and Class D felonies, as well as all civil matters and bench warrants for failure to appear. And there are no financial conditions as long as the defendant does not pose a high risk for new criminal activity, and defendants charged with felonies or those who've been deemed high risk for failure to appear are ordered to be supervised by pretrial services through monitored conditional release. And these interviews are voluntary and confidential that pretrial services offers. They're conducted in person, and we're seeing a lot of variation across all of our counties. In some cases, like in Jefferson County, our pretrial services specialists have returned to doing in-person interviews at the local jail with folks who are eligible for those interviews. In some counties and jurisdictions, folks are still, and this is with the pandemic where folks weren't allowed to be coming into the jail, they're still doing these interviews over the phone or using Teams to conduct the interviews on a 24-hour basis, 24/7 basis. The pretrial services risk assessment, which is a validated risk assessment, there's been some interesting studies and work on how this measurement works. It screens defendants for alcohol, drug abuse, and mental health issues. It also involves verifying information provided by the defendant during the interview through a criminal history check. And these pretrial services officers are using this validated risk assessment to measure flight risk, as well as anticipated criminal conduct and classification of defendants as low, moderate, or high risk to help make determinations of who can be released back. So the pretrial services specialists present the findings of their interviews and make recommendations for release to their local district or circuit court judge, and in some rural areas, especially appointed trial commissioner, who make the actual release decision, unless this delegated release authority that I was talking about before applies. Then just a couple of additional things on terms you'll hear around the pretrial services Intercept 2. One is monitored conditional release, which I brought up earlier. This program, MCR, allows pretrial services specialists to supervise higher risk defendants and monitor compliance with release conditions throughout the pretrial stage, as opposed to being detained in jail on monetary bail. Upon completion of that validated needs assessment, pretrial services staff use a supervision matrix to match the appropriate level of supervision with the corresponding level of risk and defendant needs. The most commonly used supervision tools include curfew, court notification, reporting and compliance monitoring, drug testing, and electronic monitoring. Another program that you'll sometimes hear in this context is the misdemeanor diversion program, which offers defendants an alternative to prosecution prior to arraignment after judicial referral. The intake screening process, charge information, victims' consents, and external and internal assessments are all taken into account to develop an individually based service plan. And the service plan is then written to a diversion agreement or contract reviewed by the defendant and their attorney. And this is sometimes called the Rocket Docket program, these kind of misdemeanor diversion programs in the early stages. One other piece I wanted to point out around pretrial services that you might hear about is the SB90 program. And we'll be talking about that a little bit more in the next session. But this the SB90 program was funded by the State Opioid Abatement Funds, and it's run by the Administrative Office of the Courts, as well as the Behavioral Health and Developmental and Intellectual Disabilities Department for 10 counties over 4 years. And the way that this works is that each county or jail that's participating has access to MOUD recovery services, educational and vocational activities, but these jails have to facilitate within 72 hours of booking a clinical assessment for behavioral health disorders for people determined by pretrial services to be low risk, low level by an assessor on a list prepared by the Cabinet for Health and Human Services. So this is important to know because the pretrial services team has been working really hard to get their systems up and running to be able to provide this data and kind of this just-in-time basis to facilitate that clinical assessment within 72 hours of booking for these eligible conditions. And the 10 counties that are participating: Kenton, Letcher, Madison, Clark, McCracken, Davies, Pulaski, Greenup, Oldham, Hopkins, and Christian. And they're rolling in the first 4 that I mentioned. Kenton, Letcher, Madison, and Clark are the first ones to get started here. So I'll take it over to Susannah to talk a little bit about pretrial services with this Intercept 2 work with OEND and how we've made that work given the complex system that I've just described to you.
Thank you, Margaret. So what you'll understand from what Margaret described about pretrial staff and how they go about their process is the opportunity for a confidential interview and the requirement that it's done within a 24-hour window means pretrial services staff are a wonderful point of connection with individuals who are incarcerated. The difficulty in asking them to engage in that OEND is the distribution component. Those individuals are pre-relief, and we do not know at which point they will be released, which makes that distribution component quite difficult. When we've been able to be in person, pretrial services staff adapted. They were able to have a tablet on hand, walk through that information with OEND, and help participants submit the request for naloxone to be mailed to their house. So they could walk through that process and they knew it would be complete. What happens when we switch to the virtual and phone visits is there's a disconnect in that process. It required the individual to then complete the request on their own, which meant from that point of contact with the pretrial services staff until the moment of release, they had to remember all this information and to come back to a website at the end. One of the ways in which we worked around that obstacle was to implement automated text. Pretrial services sends out, a monthly text to all participants with the number on file. And during wave 2, we've been able to expand this to an additional text that's sent to all participants 2 weeks after release, directing them to the website where they can self-request and have naloxone delivered to their house. It's been an adaptation process, but really that delay becomes a hurdle. And so making sure participants have the information they need, nothing beats being able to get them to finalize that request on site.
Thanks, Susannah. And another tool that we have here that I just wanted to mention on the slide is that we have with some of our interventions that involve having coaches and care navigators on site in the jails. We can distribute palm cards or postcards into personal property at jail release, so folks have that kind of leave behind in addition to the text message. But you might think, oh, why can't the pretrial services folks just put the naloxone unit into people's personal property? Remember, they are staff of a state agency. They're not part of the county jail, so that is not something that they typically have access to. They're doing their work on the outside of the facility in different kinds of ways. So hence the complicated workaround. Thanks, Susannah. Okay, so moving on now from pretrial services into intercepts 3 and 4 here, jails and prisons. Just to give you all a little bit of context on the difference in terminology among these different kinds of pieces here, is that jails are the agencies that we've been partnering with HCS. Jails are managed at the county level, typically by a sheriff, but not always. And jails house people who are awaiting trial, those pretrial folks that we were talking about before, people who have been sentenced for less than a year, typically misdemeanors, as well as state inmates through contracts with the DOC. So county jails are a very specific mix of people with different kinds of charges, as well as contractual holders of folks who have been sentenced at the state level with the DOC. Then when we're talking about prisons, we have not been partnering with prisons because, again, those are working at the state level as opposed to the county level of intervention that we do with HCS. Prisons are managed by the Department of Corrections or at the federal level, typically with private contracted healthcare providers, and they are housing individuals with sentences greater than a year. And then when we're talking about our reentry processes, when we say reentry, we're talking about all the services that are involved with helping people transition from jail or prison back to community settings. So a whole host of things that can be involved with that we'll be talking about a little bit later. But that's what we mean by reentry, the process by which folks are transitioning from jail or prison back into community settings, reentering citizens here. All right. Go ahead and move on to a poll. Let's just check in with you all with a poll here. The question you see, the rate of incarceration for Black people in jails from 2010 to 2019 was more than what rate that of white people? Are folks seeing the results there? Yeah, so the answer, thanks, Missy. So the answer there, we had kind of a mix of folks, the majority of folks crystallized around that second, or like twice the times that of white people, 3 times. The answer is triple that of white people, right? So when we think about the subjectivity and social construction of crime and the ways in which racial disproportionality plays out, there's lots of different ways throughout this process as we're describing it. As you hear about the discretion involved in the different kinds of classification and decision-making processes. And that's why we see the structural racism, systematic racism that's present in our whole culture being so evident in this rate of incarceration that we see with the polls. And before I turn it over to Susannah here to talk a little bit about some of the ways that we've approached providing OEND in county jails here with Madison County, just wanted to point out here that the DOC, the Department of Corrections classification process, as well as the court dockets from the earlier intercepts in this process, move really slowly. So it's very challenging to provide programming to pre-sentenced people because of unpredictable release dates and lengths of stay with bail and bond decisions or abrupt kinds of transfers. So what we wanted to come up with in terms of these different kinds of OEND strategies are ones that would be useful not only for folks who are reentering their communities after they've been sentenced and after we have kind of these clear kinds of points from the court that we can plan around, but also folks who might be coming quickly in and out of the jail with that pre-sentencing process with bail and bond decisions, where they might be in the jail for 12 hours before they're released and there's no advance notice. So Susannah, tell us a little bit about how we've made that work in the county jail system.
Absolutely. So as Margaret mentioned, each jail is operated at the county level. There is no overarching state system that sort of weaves them together. So every one of those partnerships that the criminal legal systems team established was individual and unique to itself. What we have learned and what we discussed sort of at the start of this presentation is some of the common struggles jails face. They are frequently at capacity and under-resourced, and recently they have become increasingly understaffed. Much like many of our public service industries, they have a dearth of careers, unfortunately, and many vacancies. And so while OEND sounds like a straightforward process, and indeed Gabby will make it look very clean and easy towards the end of this presentation, it is, but for an overburdened jail that's out of space and understaffed, all those educational sessions, even though they're brief, the documentation and then the distribution really can add up and add to the duties of their staff, which is something many of our jailers were resistant to. What we did find, and the most successful partnership we had, was with Madison County Detention Center. And really the reason that that was so successful is they were the first partner to really integrate HCS's strategies. They stopped being an external application and they became embodied within their processes. We were able to provide recovery staff that could support both OEND and MOUD. In Madison County, they worked with them to set goals and expectations. They gave the staff member access to their IT systems to monitor OEE so they could do the corresponding naloxone distribution. And they also gave the recovery coach access to personal property to place those units in their personal effects before they're released. As Margaret noted, pretrial staff doesn't have access to those things. When you're working with a jail, the background checks are understandably a point of security. There's lots of issues in getting through that. And where Madison was able to really want to organizationally and psychologically integrate these policies, they built a system that enabled the kind of trust they needed to allow that access. And what it meant was it reduced burden on their staff, and it really allowed, as you can see, over 1,500 of units of naloxone were distributed during our time there. Madison continues to be a model for both strategies. They are working to sustain long after we've left the field. And as you can see at the bottom of the slide, they have implemented a vending machine that continues to distribute to both individuals housed at the facility and community members as they come through the center.
Thanks so much, Susannah. And another thing I wanted to point out here before we move to the next intercept point on our journey through the sequential intercept model and the ways that we've done different kinds of HCS strategies and OEND today. What I wanted to point out is that we have in the Zoom room here other members of the criminal legal system team, including Melissa Reedy Johnson, who is the implementation facilitator working hand in glove with Madison County Detention Center to build this level of integration and trust and commitment to this kind of model that Susannah described here. So Melissa is in the room, worked with Madison County Detention Center as well as many other agencies. Mike Getz is also here, Dr. Getz is also here, and has been working with probation and parole as well as several of our other jails. Hallie Mattingly, one of our other implementation facilitators who's had experience with implementation across all of these intercept points. So I welcome questions and comments for them as well as we move into Q&A at the end. And you can ask them specific questions on, like, how did you get Madison Jail on board, right? Melissa may be able to share some strategies with that. Just wanted to point out some other team members who have some great insights in this space. Yes, absolutely, Carrie. We are so proud of the partnership with the Madison County Detention Center. That is something with pride that we share. And thank you so much for all of your support for that, Carrie. Okay, so moving to our next point in the sequential intercept map here, specialty courts. And this spans 3 through 5 in the intercept point because of the first point that you see here, that a defendant can enter into Kentucky adult trial either through pretrial diversion or on the other end, in lieu of probation or incarceration with successful completion of drug court as a special condition of probation after sentencing, right? So it kind of spans, specialty court can span the 3 through 5 of the intercept. And something to point out too, a specialty court is administered and trained and run by the state level AOC agency, but the local level staff Susannah will be telling you a little bit about their role. And when we say specialty court, we're talking about 3 different kinds of programs. Most of Kentucky's jurisdictions specialty court programs only offer drug court, an adult drug court. Some also offer mental health court and veterans treatment court, but when we say specialty court, it encompasses all of these different kinds of treatment courts that are offered in Kentucky, but we're typically talking about drug court in terms of what's actually available. So in terms of this eligibility, right, you can either enter with pretrial diversion or in lieu of probation or incarceration. The drug court staff determines eligibility for assessment. So folks can't have been a previous participant in drug court or be involved in a violent offense or a sex offense to qualify for drug court. And then the drug court staff administer the Kentucky Drug Court Eligibility Assessment, which is a modified version of the Addiction Severity Index as part of eligibility determinations. Then individual judges over the specialty court programs determine admissibility based on the defendant's current charge or conviction, past criminal convictions, if any, information from the Kentucky Drug Court ASI instrument that I just mentioned, that eligibility assessment, any victims involved with the case, defendant's willingness to participate in drug court, and the defendant's ability to meet drug court requirements, right? So all those subjective considerations are in judges determining all these different kinds of criteria and whether they are admitted to drug court. Drug court treatment typically lasts 1 year with 5 phases, and that's a change. It used to be 3 phases with a new Supreme Court order that came into effect this year, 5 phases now. And there are progressively fewer monitoring requirements as you move through the phases, plus 3 to 6 months of aftercare, usually on an outpatient basis and with contracted medical providers, usually your community mental health centers. So in a specialty court, participants must attend weekly or bi-weekly court hearings at which they answer to the judge regarding their progress. And all jurisdictions at a minimum require providing random urine drug alcohol screens, attending clinical contact hours and court sessions, obtaining and maintaining full-time employment, training or education, living in court-approved housing, paying court obligations, making individual contact with drug court staff, indicating an initial understanding of substance abuse treatment, and enrolling and attending in a self-help program. And that's broadly defined. Lots of different group modalities, including the SMART meetings that you all likely learned about with KY Open, can count towards that.
In implementing our partnership with Specialty Court, we had to acknowledge the different actors involved. As Margaret was noting, there's a state level leadership, there's the local level staff in each county, there's also the role that the judge and sort of the mood of the courtroom plays. So the way that we've approached it for OEND is sort of a 2-tiered approach. We have wonderful support from the state leadership in the Department of Specialty Courts. They're genuinely invested in their participants, but they've also been going through an internal change process while HCS has been going on. They're working towards unifying the specialty court system, and they've been undergoing training staff on new approaches throughout so that they can provide better mental health and substance use care within the court system. Having state leadership support really served the process of helping drive buy-in and reinforcing the strategies at the local level. It also meant as we needed to sort of rally the troops occasionally, we had that state leadership support to do so. So not only is HCS checking in with our local level partners, but they have that additional guidance from AOC. At the local level, the staff have been amazing. As Margaret explained their contact with participants, they are established within the community. They help connect resources, they help partner with community entities. They already have a very firm presence in their communities. And incorporating an OEND practice into that wasn't unduly burdensome on their teams. What was of great benefit to us and to communities, though, is providing that naloxone distribution. They're serving as role models. Specialty court giving out naloxone in the community both normalizes and destigmatizes the carrying of naloxone. They were able to set models in their courthouses. They did staff trainings, all of those pieces, but it was really their community ties and their willingness to bring HCS strategies along with them that provided great success. They've been present at Memorial Day events, July 4th parades, Labor Day, and have been really able to do wonderful distribution numbers.
Thanks, Susannah. And so the picture that you see here is one of our Wave 1 specialty court program supervisors along with his local sheriff, right? And they had provided and they had done an OEND event with the sheriff's office. Okay, so on from specialty court to the final stage of the sequential intercept map that we're going to be talking about today in conjunction with OEND efforts, probation and parole. So just some definitional terms here on the slide. Probation, both probation and parole are part of our partnerships in HCS. When we're talking about probation, that can occur either pre or post trial, which is ordered by a judge at sentencing or trial. Probation officers monitor adherence to probation terms. So that's what probation looks like. Parole is specific to release with conditions after serving a sentence, after, of course, being charged. And that's determined by a parole board. In calendar year 2020, which is the latest that I have data, there were more than 16,000 parole board hearings in Kentucky. And then parole officers monitor adherence to parole terms. Well, what are these parole terms? And the important to point out is that violation of the terms and conditions of parole can lead to revocation of probation and parole terms and reincarceration. So that becomes another point at which folks can return to the carceral setting. The terms and conditions related to substance use, and these are standard terms and conditions for folks on probation and parole. I understand that I shall be subjected to search and seizure without a warrant if my officer has reasonable suspicion that I may have illegal drugs, alcohol, or other contraband on my person or property. I understand that I shall not use or possess any alcoholic beverages or enter any place where they are sold as a primary commodity like bars or nightclubs, or narcotics or controlled substances that are not currently prescribed to me by a licensed physician. And then I understand that I shall submit to alcohol and or drug testing and shall pay for said testing if directed by my officer. I point out those terms and conditions to highlight the fact that issues related to substance use disorder are part of standard terms for folks who are even not involved with drug court, right? This is part of often the terms and conditions of probation and parole more broadly. And typically, another point to know is that probation and parole supervision is not free for the folks who are receiving it. There's typically a supervision fee charged to folks in addition to their other court fees of $10 to $25 a month to pay for the supervision that they're receiving in these kinds of cases. All kinds of additional terms that can be added in addition to the standard terms, including attending drug treatment, paying restitution, no contact orders, child support payments, curfews, more frequent reporting, job searches, right? So you can see the ways in which these terms and conditions become somewhat complicated for folks who might be pursuing substance use disorder treatment. So a little bit more here, again, so you all get a sense of how probation and parole works. Like the administrative office of the courts over pretrial services and specialty courts, probation and parole is under the jurisdiction of a state agency, the Kentucky Department of Corrections. And again, like I say, they're responsible for probation and parole services. A state agency of the Kentucky Justice and Public Safety Cabinet, the DOC operates state-owned adult correctional facilities and provides oversight and sets standards for county jails. So you can see some of the different points here of the folks we'll be talking about. Division of Probation and Parole, Division of Addiction Services, under the broader Department of Corrections, along with these state prisons, correctional program supports, health services, all of those kinds of pieces that go to the state-owned jails. The Division of Addiction Services is responsible for the clinical and administrative oversight of all STD treatment related to inmates, parolees, and probationers within their care as determined by statute. This oversight includes treatment in prisons, jails, reentry service centers, recovery Kentucky centers, and intensive outpatient programs through a partnership with regional community mental health centers. STD clinical determination for probationers and parolees through a network of social service clinicians in the probation and parole districts are also included in this oversight. So parallel to the probation and parole officers, we have the social service clinicians run by the Division of Addiction Services, providing the support to getting folks connected to treatment and managing that in coordination with those complicated terms of probation and parole that I reviewed earlier. So how the heck did we do this, Susannah? How the heck did we do OEND with probation and parole?
Well, we took two tacks. As you can imagine from the requirements Margaret was reading, there's also a whole laundry list of additional requirements that follow that. And P&P participants are laser focused on meeting the terms of their requirements, and it's quite a stressful environment to come to the officer they're reporting to. We took two approaches. Our prevention specialists were there on site to occasionally deliver DDoE&D, either in the lobby or when weather permitted outside of the office. With the thinking outside of the office being that it's a little bit further removed from their probation and parole officer, they can have a bit more privacy and they're a little bit less under the watch of their officers. The other strategy that was deployed, much like pretrial services, was a self-request website. This was actually originally developed as a COVID workaround, but what we found over time is it's successful as a discrete mode of access. As we're saying, the probation parole participants, they're very concerned about the message they're sending. They're there to quickly meet the terms of their probation, but they don't want to do anything that they think reflects on their own behavior. And a lot of the time there's a misunderstanding that carrying naloxone says something about the individual that has it on their person. What we've worked really hard through education and training with the probation parole officers and with the community at large is to characterize rightfully naloxone as a pro-social bystander tool. It is something that you have on your person to save lives, to be a good member of your community, and to be proactive on that front. And so with this self-request website, you still have the thing of how do we get people to follow up through it, especially in a stressful environment. So we deployed several tactics to try and encourage and direct traffic towards that website. There were TVs in the PNP lobbies displaying information about OE&D, posters throughout the offices as well. Officers distributed palm cards with information about the website and HCS. Again, we were able to work with DOC to implement automated text messages. At the moment, we currently have one that goes out monthly, directing people towards the website, and we also have one that goes out directing people towards MOUD services as well. We directly mailed letters to the home of participants in all eligible counties, and then the DOC was willing to adapt their own website and provide a brief blurb, and you can also follow through on links to self-request naloxone through their website. Across the board, it's been varying success. I think we found no matter what, that one-on-one conversation is going to do the best work, but providing this option out of the watchful eye has been productive.
Thanks, Susannah. And yeah, we have one more poll before we talk a little bit more about one of the experts in how you strike up those kinds of challenging conversations with folks as they're reporting and talking about OE. What's your answer to the question? Technical violations are the main reason for the incarceration of people on probation and parole. Lots of correct answers here. Might have been a little bit of a leading question given some of what we were talking about before. Yes, it is true that technical violations are the main reason for the incarceration of people on probation and parole. Yet another source of some of the challenges around overcrowding and staffing in our county jails. So now I'd like to turn it over to our pro at engaging people involved with the criminal legal system in OE&D, Gabby Deaton, to talk a little bit about her experiences in all different aspects of the criminal legal system, especially the probation and parole offices, in getting folks to take naloxone with them, given the high risk of people, especially as they're going in and out of the jail. I hope something that you took away from our presentation today is the kind of unpredictability with which folks can be coming in and out of that incarceration setting, where it becomes more and more challenging to provide people with just giving them that unit of Narcan, right? And that could save a life here. So Gabby, we'd love to turn it over to you to talk a little bit about how you approach this and some of the strategies that you use for engaging folks who might be rightfully concerned, as Susannah says, about the impacts of taking naloxone on their terms and conditions of parole and probation.
Perfect. Thank you so much, Margaret. So as mentioned before, I am the Prevention Specialist Coordinator for HEAL. So I get the opportunity to work with all 8 of our prevention specialists in all 8 of our Wave 2 counties. The prevention specialist experience is something very unique and very interesting because we get to work with so many different people and in so many different communities. This experience working with HEAL and the distribution of naloxone has been extremely rewarding for me as a person in long-term recovery whose life was saved by naloxone twice. So now coming full circle, being able to, once be on probation myself, and now being able to distribute at probation that same life-saving medication that saved my life is extremely rewarding. And I'm very glad to be talking to you guys today. So generally, really quick, what do the prevention specialists do? The prevention specialist team, or the PS team, works to identify locations in the community for the direct delivery of OEND. So those can be places like libraries, gas stations, pawn shops, recovery housing, festivals, corner stores, and even probation and parole. We've even had prevention specialists in some of our counties placed in the county jails. Once the prevention specialists locate a venue or setting to set up, they get to work. And so what does that look like? You saw a photo of one of our tables set up in the probation and parole office. And so that's pretty much what it looks like, except we have the opportunity to set up inside venues. So inside Goodwill or probation and parole. I know in Boyle County, we were set up in the jail, working with people as they were being released from incarceration. Or we can set up outside. So we find a busy street in the community, we set up outside, and we can offer to community members driving or walking by. The prevention specialist team in wave 1 and 2 has distributed over 25,000 units of naloxone. And that's by a team of generally like 8 to 10 people throughout the entire process. So that's a lot of naloxone and a very small team. But that's huge. That's 25,000 people's lives potentially saved. So our response from the community, we emphasize that Narcan is a pro-social bystander behavior. So one of the biggest things that we get when we're out in the community and when we're in probation is, I don't need that, or I don't need that anymore, or I would never need that. My family doesn't need that. And what we try to educate the community on is it's not about you. It's not about your individual self, because you're not going to use the naloxone on yourself. It's about being a good community member. It's about protecting your neighbor. It's about accidental overdoses that happen with left out pain medication from surgery. And so we try to go through all of those things that allow the individual to think outside of their own personal selves. And we have a lot of success in doing that. We still get some people that choose not to get the naloxone and get educated. But we do see a lot of people's minds change, and it is really neat to see that experience. But one of the biggest things, like I said, is that people just don't understand why they should carry naloxone before we get to speak with them. We get a lot of positive feedback from the community, but unfortunately, we also get some negative responses as well. These negative responses are generally due to misinformation and stigma, lack of education, or a negative personal experience with a family member or friend. Our prevention specialist team has been instrumental in their ability to combat these negative responses with education and respect. And we've seen those change as well. We've seen people who come up to our table with a negative perspective on naloxone and overdose education shift. And it is really neat to see those as well. But unfortunately, sometimes it just ends up with telling people to have a great day. So shifting to CLS and OEND at probation and parole. This has been an extremely different experience for us because when we started, we were all setting up inside of the probation offices. Some of our prevention specialist team were given offices, just empty offices that they could set up in when they came. Some of us were setting up in the lobby where the individuals were waiting to be seen by their probation officer. And what we noticed fairly quickly was that people were somewhat uncomfortable with speaking to us. You have a group of people who already feel like there's eyes on them all the time, and they don't want to make a mistake, especially while they're in the probation or parole office. And I think that they didn't want to draw attention to themselves, or they didn't want their probation officer to think, why do they need that naloxone? Why are they getting that? What are they doing? And so we saw a lot of hesitation. And through that process, we changed a few things. We engaged more with the staff at probation and parole. So we really tried to build a relationship with them. We trained the staff. We welcomed them when we came in, said hi, learned their names, sent emails. And that really helped because we were able to encourage the probation and parole staff members to encourage their clients to come see us. So when your probation officer at the end of your meeting says, hey, why don't you stop by and get Narcan or naloxone because you could help somebody else, that kind of relieves that pressure off of them or that worry off of them. So we were able to do that. We were able to find probation and parole officers who would refer them to come out and speak to us before they left. In some counties, we were also kind of able to team up with the probation and parole officers. So in Kenton and Campbell County, we had one probation officer who was willing to let her people that she supervised report via telephone the next month if they came and got naloxone from me. So she would come out and make an announcement, and every single one of her parolees or people on probation would stand up and come get it, where they had been sitting there for about 45 minutes, kind of ignoring me. They would instantly come and talk to me. And so that was huge. I know in Mason County right now, they're working on some type of incentive like that as well. And that's really helpful. And then another thing that we did was we removed ourselves from the office. So in Campbell County, if it's not raining and it's not 105 degrees like it has been this entire week, I'll set up outside of the probation office. And that allows us to separate ourselves. We are not probation. We are not your probation officer. We're not going to tell them that you came and got this. It also allowed us to reach their family members and friends who were driving them to and from probation. So in some counties where that was possible, where the location allowed for that, we saw great success in that as well. And we also distinguished ourselves apart from the CLS and the probation and parole. We, like I said before, anytime that we were talking to people, we made sure they knew that we were not affiliated technically with the probation and parole office. And I think that made people feel more comfortable talking to us and telling us things and opening up about what was going on in their life. Provide OE&D to staff to increase awareness. That goes back to training and making connections with them. Every time that I'm set up in Campbell County, 1 or 2 probation officers will usually come out and get another box. They either had to use it or they gave it away to one of their clients while we weren't there or something like that. But that connection with the staff at probation and parole is extremely important. And then we've had a lot of experiences where community members are coming back and telling us that our naloxone has been used to save a life. And while that's kind of bittersweet, because of course we never want anyone to overdose and we don't want the naloxone to have to be used, we're very grateful that in those instances they were able to get it and save that individual's life. The thing with our study is that we don't necessarily track where the naloxone goes. So we don't know how many for sure of our naloxone units have been used to save lives, but we have had hundreds, if not thousands, of responses where people have told us that it's been used to save their mother, their friend, themselves. A few examples would be, let's see, in Kenton County in wave 1, it was maybe our second time setting up. So we were fresh. We were just trying to figure out what we were doing pretty much. And we distributed naloxone and overdose education at a recovery meeting. About a few weeks later, the woman that we trained reached back out to me and said that it was used the night before to save her life. She was headed to treatment. She now follows me on Facebook. And so I saw not too long ago, she just had her first baby. She's been in recovery ever since. And that's one of those very feel good, like, her life was almost over, but her friends knew she had naloxone. She was saved. And now she's a mother living her best life. And it's really beautiful, especially for me right in that one, because I get to kind of see her grow. But I know in Knox County, our prevention specialist, Danielle, was distributing at a subsidized housing complex. And one of those units very soon after was used to save the life of a teenage boy. And then that housing complex requested a nalox box for their laundry room. So even those stories are having even bigger impact, because it allowed for that subsidized housing complex to be like, we don't ever want to be in this situation again and be unprepared. And so they installed the nalox box in their laundry room. And we get flooded with those stories from the field of where our naloxone's been saved. I'm sure any CC or prevention specialist on this call could give you a handful of their own personal experiences. But it has been a wonderful experience and journey with HCS so far, and we are very excited to continue these efforts. Thank you guys so much.
Thank you so much, Gabby. And thank you for the work that you lead on behalf of your team. Just so grateful to have your insights and experience in this work. So we have about 10 minutes left for some Q&A. And of course, knowing that we'll have more time next week for additional questions, love to open it up for any questions you might have for me, for Susannah, for Gabby, as well as all the other CLS team members who are on the call with us here.